Lawyers of Reddit. What is a detail that your client failed to bring up to you that completely lost you the case? Story 1. A friend of mine is a lawyer, and he said that a client once turned up to court in the actual same outfit he was wearing in the burglary. When the CCTV footage come up in evidence, the client looked down to himself and was like, "Ooh, edit my first ever awards. Cheers." Story 2. Unfair dismissal case. The client claimed to have been dismissed without reason or following procedure. After we had started the case, it comes out that not only was he given 3 written warnings, but he was also called in for a disciplinary hearing before his dismissal. Don't lie to your lawyer. Story 3. Not a lawyer yet, but I clerked for a DA's office throughout law school. Obviously, we don't have clients, but I'll never forget this kidnapping case I worked on. It involved 2 Asian male defendants who were both the same age and looked relatively similar. Witness is on the stand and is asked to identify where the defendant who pushed an Uzi into his face is seated. It's clear the witness is having trouble differentiating the defendants. In a true moment of brilliance, one defendant raises his hand and basically points to himself like, "Right here, bud." Hands down the dumbest ID ever seen. I thought his defense attorney was going to have a brain aneurysm. That he filmed his offenses for his YouTube channel. The cops didn't even know. A witness brought it up on day 3 of a trial. It was a nice quick change of plea that afternoon. Story 4. I'm actually a lawyer, but I was only watching this trial, not participating, so the case was that woman A had hit woman B in the head with a heavy beer pint at a bar, and woman B got pretty serious injuries. The defense claimed that woman A had not hit anyone with a pint, but instead had just thrown the pint into a random direction, and it happened to hit B in the head. Thus, it was an accident and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial. And the tape clearly showed in HD as they walked behind B and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer, and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along thrown, and the defense lawyer said that due to technical difficulties, he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty. So yeah, I was completely dumbfounded. Story 5. A defendant was written a cell phone ticket while driving and defended himself. Your Honor, I was not using a smartphone while driving. I was actually using a flip phone. Guilty. Story 6. I'm a public defender in an area with lots of meth use. Meth makes most people talk a lot. So I can't tell you how many clients forget to mention that they got to the jail still high and call their mongrel friend buddy on the recorded jail phone and not only confess the crime, but also brainstormed whatever alibi or version of events I'm relying on to defend them. Edit him seeing this question a lot, so they'll add some info here. This is not legal advice, just explaining things a bit more. Calls to a lawyer are privileged and generally go through dedicated lines that aren't recorded. Depending on the facility, calls to family, friends, etc. through the normal phones are not privileged, are generally recorded, and can be used in court. There are usually printed signs near the phones and a recorded warning before each call that this is the case. Story 7. Employment law matter. He claimed to have been unfairly dismissed over bogus performance management. The real reason he organized via Craigslist to have someone collect a box of his from children's playground, there were explicit messages from him asking what they did with it and whether they rubbed it all over themselves. The employer provided us the messages. Edit, he was doing this on company time. Story 8. Case as a paralegal, negligence case. Client argued that a lack of street lights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with playing on the phone. Wasn't difficult to figure out who was negligent at that point. Story 9. Not a lawyer law student and not exactly what you asked for, but I feel like it fits here anyways. We read about a criminal case in which there wasn't enough evidence to convict the suspect. So the suspect was not guilty due to reasonable doubt. And he responded, "Thank you, judge. I'll never do it again." DA went into appeal, and dude got convicted. Story 10. I'm a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties in Department of Children, Court Services, we have a pre-trial to try and convince guardians. I meet with my client before the hearing to see if anything changed. Nope, all good. Let's get my kids. Great, that's not happening today, but let's try we get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1, that no longer is working, 2, no longer an apartment, 3, doesn't want to have a relationship with guardians despite her kids loving them, 4, Won't send her kids pictures of the toys they miss, and can't have 5, plans on moving out of state 6, thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant, all in a matter of 15 seconds. I was too shocked to even react, speechless. Not the image of stability and parental fitness I've been trying to paint since last July. Edit to clarify, client was working really hard to get everything right, and legitimately had everything going for her prior to this hearing. I was not making false representations or trying to get a monster reinstated. This was a true bombshell as I did my due diligence to make sure things were on the up and statutory requirements were met. Things fell apart very fast apparently. This was a very atypical situation. Parents typically do a really good job working hard to meet their requirements. Story 11, not my client, but the son of the opposing party, and presumably the party himself lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took the witness box. Their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favor shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case Shed ever handled. Story 12 had a woman with an expensive fur coat, and she claimed that the laundry ruined it. It was kind of ruined, but the laundry claimed those stains were already there. Judge ordered an expert opinion lab, and the fur coat had traces of cocaine and other illegal drugs all over it. There was a raid at her place then, and her husband got convicted because they found several kg of drugs. Story 13, I was involved in a hit-and-run car accident. My leg was pretty mangled, however the driver of the car was caught. Turns out he was a rich kid who was driving his mom's convertible Porsche, denied all knowledge of hitting me, etc. At the trial, the prosecutor asked him how long he had been driving, to which he answered, "Do you mean how long have I been driving legally or illegally?" The judge then went nuts asking why. And when he had been driving illegally, his defense team sat down in their chairs and shook their heads. Needless to say, he lost the case. Interestingly, he died a year later by drowning. He had hired Speedboat and Holiday, flipped it over and drowned. Turns out he was drunk at the time. Karma can be a... Story 14, not a lawyer. My parents had a long, messy divorce that took 5 years in court. My dad claimed that my mother was trying to take 100 of everything based on a settlement offer she sent him. He failed to mention to his lawyers that her initial offer also sent to his previous lawyers was a 6,040 split, and she only sent that 101 in response to an equally unreasonable offer from him. As soon as she could prove the initial offer was reasonable, the judge just basically ruled on everything according to that first offer. His lawyers were so angry because they built their entire case around the idea that she was the unreasonable one. I think it was something to do with arguing that she was not sending genuine settlement offers. I'm not sure why. His goal wasn't to win, it was to prolong the battle. But the original offer exposed him in the lie in front of the judge, which made the rest of the process go very quicky. Story 15 UK, not a lawyer as such, but a planning consultant. Client signed sworn affidavit stating had been running a truck park business for over 10 years on a piece of land. After 10 years, the use becomes immune from legal action. The counsel checked Google Maps and saw immediately he lied, had only ran the business for 7 years. He had committed a criminal offense by submitting a false sworn affidavit. Not me, but my mentor. This is the reason you never ask questions that you don't already know the answer to in court. During the trial with the judge on a divorce matter, the wife brought up that he had abused her during the course of their marriage. Client whispers to my mentor that that is absolutely not true. On the stand, during his portion of testimony, my mentor asks, at any point in the marriage, did you lay your hands on your wife? One time we were having an argument, and I held her down on the couch until she stopped arguing with me. My mentor said it was like she could see it happening in slow motion, and all the alarm bells were going off in her head because he had never mentioned this, and apparently to him, this was not abuse. The judge gave wife a lot more money as a result, and husband was baffled. My mentor was fuming. ETA, husband admitted this was the only time he had laid hands on wife. My mentor was more peeved because she had thought the case was in the bag since wife had abandoned the kids with husband to run off with her lover down in Florida and literally only came back to the state to get the divorce done. Husband had been noted as being a great dad to the kids and a good figure in the community, hence why she was so shocked at his answer. Story 16, this one ended my marriage well. It was the start of the end of marriage. My husband lost his job in the title mortgage business, applied for unemployment, got denied. I decided to help him with his appeal hearing. I asked him multiple times before the hearing, is there anything you did that caused them to fire you? He says, no, absolutely not. They fired him out of nowhere. Hearing day comes. He testifies under oath that he did nothing wrong, was a good employee, no issues. Upon cross-examination, the other attorney pulls out documents from one of his real estate closings. Documents he forged and backdated, had to admit he perjured himself. Needless to say, he didn't get unemployment, and he didn't sleep at home that night. Story 17, not a lawyer, but a woman I know received several hefty speeding fines. In my country, you can go see a magistrate to have the fines reduced if you plead poverty. She heard about this and decided to give a shot. So she went to court and told the magistrate a sob story about not having enough money. The magistrate heard her out. Then he asked her, "Madam, what type of car do you drive?" She replied in a tiny voice, "A Porsche." Many have raised a fair point that a Porsche doesn't necessarily cost that much and isn't indicative of her financial status. So I'll add that it was not a beat-up or old model at the time. She could have paid the fines without breaking the bank. She was just pushing her luck. She's a wealthy woman who just didn't want to pay her fines, and the magistrate wasn't having any of it. Story 18, not me, but my dad represented a guy in a civil case. He doesn't normally do criminal law, but in this instance the question of a forged signature came up, and his client lied, saying he didn't forge it. My dad was very clear in explaining that admitting to him wouldn't land him in jail. It would just allow him to build a better defense. But he still denied forgery, and so my dad rolled with it. He said his case was completely cut up once it came out that yes, in fact, his client did forge the signature. Guys and gals, your lawyers aren't a snitch. They're trying to get you the best possible result. Always be honest to your lawyer. Story 19, guy in prison hired me to request a modification of a sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down head, never filed before. You could see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record, basically finally arrived. Head personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. Story 20, friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically, this guy took an AC unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they're charging me with assault. I never touched her. I just threw an AC at her. This is bullshit." Judge rescinded plea deal because of defendant's attitude, lack of remorse, went to trial, and got a year in jail. Story 21, not a lawyer, but going to law school, I worked for a defense attorney who did a lot of federal work. One of our cases was with this guy charged with trafficking of minors. We met him at the prison to interview him, and he swore up and down he had nothing to do with this and that he didn't even know the girls. A month or so later, heaps of evidence from the U.S. Attorney's Office comes in, and it's pages of Snapchat messages and text between him and these girls, video confessions from every co-defendant and victim saying our guy was the ringleader, proof of him checking in out of different motel rooms, etc. We showed him the evidence, and he claimed his co-defendants were conspiring against him. He continued to deny everything and wanted to go to trial, but we repeatedly told him that would not be wise because of all the evidence against him. He ended up requesting a new attorney to be appointed, claiming that we were ineffective. To this day, my old boss and I reminisce about how difficult this client was when we catch up on the phone. Story 22, I was actually on a jury. Guy was suing a business. Said he got injured, couldn't work for 3 years. Defense counsel, sir, isn't it true that you spent 18 of those months in prison for armed robbery? Edit for more info. Guy was saying he was shopping at a major grocery store chain and slipped in some water on the ground in front of freezer. Guy has cell phone video his wife made of him in the water, and we could hear her saying that the water wasn't showing up on video and to splash it with his hand so it would look better in the video. It also came out that Head had 3 prior convictions for crimes of dishonesty that may not be the exact term, but something similar for things like shoplifting and other petty crimes. Second edit for more info. While I'm on my lunch break, Guy was representing himself pro se. Defense counsel asked him if his inability to work could be from the 2 previous knee injuries Head had. When asked how they knew about those injuries, he was told his previous lawyer had given the defense his medical records upon request. Guy wanted to enter his MRIs as evidence, but had no one there as an expert witness to explain to the jury what they showed. He wanted to show us what the results were. Story 23, lawyer in the UK. I acted for a member of a famous pedophile hunting group. My client was charged with various offenses relating to his vigilantism. most seriously, causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defense point that is not available to him in statute or at common law contrary to my advice. I followed his instructions as I'm bound to do. If the state won't punish pedophiles properly, then it's left to men like my client to take the law into their own hands. A horseshit argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of child pornography on it. He himself was a massive pedo. Edit spelling, edit to spelling again. Story 24, not mine, but saw it in Rental Parents. The case was about a woman who took the car from her daughter and grounded her. The daughter called the police, and the court proceedings began. Apparently, the woman didn't tell her lawyer that the daughter was 22 years old and didn't live with her mom. The mom decided to go to the daughter's place and took her car out without her knowledge. Story 25, my father is a judge. I remember him talking about a case where a woman was suing for a severe back injury that she said was preventing her from working and taking care of her kids and so on. In the middle of the trial, a pen rolled off the table, and she is bending over trying to reach it from her chair, but pen was too far away. So she stands up and bends over and picks it up and goes back to her seat as if nothing is out of the ordinary. My dad is just looking at her, and she snaps at my dad and goes, "What are you staring at?" My dad asked her if she was okay, and her response was that she was fine. Her attorney leaned over and said something to her, and she then loudly started complaining about her back and how much her back hurt, but no one believed her, lol. Story 26, not me, but my legal studies teacher who used to be a lawyer was representing a woman suing a supermarket for a slip that caused her to hurt her shoulder. She had to tell the court how much it had impacted life and the fact that she couldn't do her everyday tasks. She said, "I can't even lift my arms like this to hang the washing," and proceeded to show the court the exact gesture in perfect form that she was explaining she couldn't do. Story 27, I was approached by this attorney to work for him for free to go after smugglers. This guy had been arrested for dumping goods onto American markets that violated trade agreements. In his arrest, a bunch of goods were left in warehouses to rot, and their owners, his clients, were never paid. This attorney showed me that this smuggler had assets, and that he had gone to the criminal trial and gotten the judge to set aside $2 million of the criminal penalties to settle his client's debts. He had receipts, invoices, all of the paperwork. He just needed associates to help him take the case to trial. He wanted me to work for free, but he would pay me on contingency once he obtained a verdict. He had 2 other attorneys working for him with the same deal. I worked on the case for a short while, but luckily moved on to other things. The other 2 attorneys worked on that case for over 2 years. At one point, they negotiated a $1.5 million settlement of all claims. The attorney in charge rejected the offer because he was convinced he could get twice as much at trial. In the end, the case settled for $200K because none of the clients would enter the United States to testify for fear of being arrested. The 2 associates got $8K apiece for 2 years of work. Story 28, a postcard. While I was in law school, I worked in a state AG office, Administrative Appeals Division. Guy was appealing a huge tax bill for unpaid tax on his dairy farm's milk production. His entire defense and claim basis for appeal was that he had zero notice of the requirements to report production, sale, and proceeds. An initial disclosures pile of discovery was a postcard from the state tax office from when he initially registered to obtain a state tax number. Very smart AG laid low, sprung it on the guy after he had cemented his position 50 ways to Sunday, exploded his whole theory, resulting in big judgment. Moral: read your own discovery responses and document production before building your entire theory of the case. One piece of paper can kill your client's position. This lesson has saved my bacon in 27 years of practice for sure. Story 29, opposing counsel. Isn't true. You hit victim in the face with a brick. Client: no. Marcus hit him with a brick. I hit him in the back with a piece of when I was a law student. I interned for a judge. One of the cases we were observing was an illegal lockout case, where this owner of a franchise location for an international cafe company claimed the landlord owner of the right to issue franchises in the U.S. happened to be same guy, just one day locked him franchise owner out. Landlord had claimed the franchise owner was selling unapproved merchandise with the company's logo on it. For 2 days, all we're hearing is about these cups. The plaintiff allegedly made argument was that counterfeit merch violated terms of franchise and lease, which meant terminating both finally. The landlord is on the stand. The defense attorney pulls out a shopping bag as he's about to introduce evidence. Me and the other interns are so excited. For 2 days, we've been hearing about these cups, and the landlord suddenly can't remember where he got the cups from. In response to one question, he says he got them at the cafe. In another, he says the corporate office gave it to him, since he raised out about the source of the cups. The judge wouldn't let them in, and we never got to see them. The defense attorney had to sadly put the bag away back in his briefcase. So yeah, lesson learned. Prepare your witnesses, especially when you're trying to introduce critical evidence. Story 30 credit card theft fraud case. When I was a young lawyer back in the late 80s, I was trying this guy on a CC case, and the witness was the department store clerk. Before video surveillance, the state relied heavily on witness identification. As she described the customer that was purchasing the very unique clothing her store sold, I asked her how could she be so sure it was my client. She looked at my client, who was wearing the most obnoxiously yellow shirt imaginable, and said, because not only does he completely match the description I just gave you, but he's wearing the exact same shirt I sold him. The jury convicted him, and I learned that day to better prepare my clients for trial. Story 31 Head sent a photo of his wife's beaten face to his wife with a message saying something along the lines of this: do you want this to happen again? He came across very well in court up to that point, but his mask slipped when that came out. Story 32 Not mine, but went to court over a ticket. Lady was in front of me for DUI and hit and run. The judge assigns a lawyer for her. Since she was so shook she quit her job, the judge asked the prosecuting attorney for details on the case. She legit says, you mean that car I hit while I was intoxicated? The judge stops, takes his glasses off, and says, everything is recorded in this courtroom. I told him not to talk to anyone about your case except the attorney that I assigned for you. You could tell he was ready to walk out of the room with the level of stupidity this lady showed. Story 33 When I was an intern at court, I was watching a battery trial with another intern. The defendant was asked if he can remember how many people were present when he beat up the other guy. He then points at my fellow intern and says rather loudly, she was there, but she didn't see anything. Don't trust her. Of course, she wasn't there, and the defendant was found guilty. Story 34 I wasn't a lawyer in this role, but was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long, drawn-out case that took about 5 days. Right before the closing arguments, the attorneys wanted to talk to the judge. It seems as though a couple of days prior, the couple decided to get back together, and instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, brought in experts such as land assessors, financial planning people, and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out the courtroom. The judge had to dismiss the jury, and the couple was adamant that they didn't think that them getting back together was a detail any of their attorneys needed to know. Edit yes. In some states, there are jury trials for divorces. However, this particular case wasn't for the divorce, but for a cause of action stemming from the divorced marital property. It was a jury trial. Story 35 A buddy of mine case. As a public defender, a gal was busted on drug charges and told him she didn't have any drugs on her when they arrested her. He thought, okay, we'll use that. Turns out, she didn't have any drugs on her when they arrested her because she just sold them to an undercover cop. Story 36 Not my case, which is a gift from above. Really civil trial before a jury for injuries and prop damage from MVA and punitive damages because defendant was intoxicated at the time of the accident. Let's call defendant DUI. Almost doesn't need to be said, but before DUI ever stepped foot in court, they would have been prepped repeatedly first for the deposition and then for trial testimony with the standard questions. Were there any prior incidents, arrest convictions, anything that could be used to impeach any of DUI's testimony, yada yada, over hours. Denies everything and is as clean as a clean whistle. Thus, at trial, defense counsel DC puts DUI on the stand to give them an opportunity to tell the jury of their contrition for this one-time error in judgment, describe the difficult time DUI was going through at the time, and otherwise show themselves to the jury as an upstanding member of society in order to reduce punitive damages. It goes well. Then plaintiff's counsel PA gets to cross. I'm going to paraphrase what allegedly happened next, which is purely hearsay. PA, earlier, you testified that this was a one-time mistake and you've learned your lesson. Is that correct? DUI? Yes. PA, ISN true that you've already been convicted of DUI in another state. DUI sits silent as DC immediately objects, but it's properly overruled and DUI must answer. Since what happens next is impeachment, it'll skip the objections, but suffice to say they were being fired off as rapidly as a machine gun. And just as rapidly overruled. DUI, yes. PA, and ISN true that in your prior DUI a child died. You can imagine what's happening in the courtroom, and most importantly, amongst the jury, and you think it's over. Stick a fork in DUI, it's done. But then PA goes for the jugular. Do you remember the name of that little child that you killed while you were driving while intoxicated? This question is one for the ages, more powerful than the old when did you stop beating your wife, because no matter how you answer, and that is why you never, ever lie to your attorney. I primarily represent plaintiffs in personal injuries cases, and, ooh boy, I have a few. The most memorable was probably during the hearing in this road traffic accident case. Based on all the evidence up to that point, it had seemed like a pretty clear-cut case of my client being cut off by the defendant when he decided to exit the motorway at the last minute. The defendant takes the stand and says that in the aftermath of the accident, my client's friend, who had been her passenger, said to him that she, i.e. my client, was not looking this friend who is Polish but has lived here for 10 years, is then giving evidence, and it's put to him that he made this statement. He responds in English that I don't speak English, so I couldn't have said that. Our barrister just looked at me horrified. I also recently had an employment law gender discrimination case where the whole thing essentially revolved around whether they had told her that her position was being terminated as a result of genuine redundancy legal versus whether they terminated it after she got pregnant, obviously illegal. This distinction was emphasized to the client many, many times, and she strongly maintained that they fired her right after she applied for maternity leave, without giving a reason. We're having a meeting with the client the evening before the hearing and going through what the defendant will say, etc. We tell her they'll be claiming they told her it was redundancy. And how is she going to respond? She replies with absolutely no hesitation, "Oh yeah, of course. That's exactly what they said." And then there's generally a shocking amount of people who genuinely completely forget what day an accident from which they supposedly sustained drastic injuries from happened on. Edit, because people are rightfully pointing out that some people are just bad with dates. I don't mean not remembering the specific date. I mean like coming to our office about a very recent accident, but not being able to say whether it happened last weekend or the weekend before. If it's apparently significant enough to sue over, it can't be that forgettable. Story 37, not strictly a court case, but boneheaded stupidity. A number of people have given a false name to police to avoid an arrest warrant, but got arrested when the false name matched someone with an outstanding arrest warrant. Story 38, there's a rule you're supposed to follow when questioning trial witnesses, and that rule is to never ask a question you don't know the answer to. Despite this rule, lawyers often ask small, apparently inconsequential questions which are necessary to set the scene, but are so inconsequential or obvious that their answers are fairly presumed. This case was an exception to that general presumption. The defendant was arrested on a warrant and transported to jail. After booking him into jail, the officer returned to his vehicle and discovered a baggie of drugs sitting right in the middle of the back seat. The defendant was charged with possession. At trial, the officer explained that he routinely searches his vehicle before his shift starts and after any time he transports someone in the back seat. The defense attorney tried to poke holes in the story, but the officer's testimony was remarkably consistent. The officer was fastidious about checking his vehicle. The appearance of the drugs coincided with the defendant's presence in the vehicle. Then, as the defense attorney was running out of questions, he threw out the question, was there anyone else in the back seat of the vehicle? It was a Hail Mary. Even when there are multiple arrests, police tend not to transport more than one arrestee at a time if they can help it. There was no reason to believe anyone else could have feasibly been in the back seat with the defendant. Though it's no surprise to you, the defense attorney and prosecutor were stunned when the answer came back as yes. Turns out, the defendant was with his girlfriend when he was arrested, and the officer courteously agreed to drive her to her apartment before taking her boyfriend to jail. This fact was not included in the police report. The officer never told the prosecutor, and, shockingly, the defendant never told his attorney. There was a palpable pause as this fact sunk in, since there was another person in the back seat. There was more than enough reasonable doubt. Proofs were concluded, and the prosecutor threw out a half-hearted closing. The not guilty verdict was a given. Because of this case, I learned to never assume a fact no matter how obvious it may seem. Story 39, my client was the defendant in a marijuana trial. At one point while she was testifying, I noticed the jury looking down at her legs and feet. She had a tattoo of as marijuana leaf on her ankle. This was the 1980s. She had always wore pants in my office. She wore a dress to court. Guilty. Story 40 had a client charged with reckless driving for going 200 miles an hour with his pregnant girlfriend in the car. Dude showed up to court with a shirt that had a huge logo of Acme Racing on it. It was years ago, and I can't remember the actual name of the racing team. Another client showed up in court very nicely dressed and had even ironed his jeans, but the jeans had giant marijuana leaves all down the front. At least he wasn't there for a drug case. Story 41, over my summer internship. I helped with trying to get some evidence admitted. The evidence was recorded audio of mental abuse over the phone, daughter talking to father. Lawyer spent a while trying to show there was no expectation of privacy for the conversation. Client went on stand, and the first thing she said regarding the audio tape was that she always stays as far away from her daughter and lets the daughter lock her bedroom door so that their conversation has the utmost privacy. It wasn't admitted, LOL. Story 42 minor traffic cases can be the worst for this, believe it or not, because they're short and simple, and oftentimes the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour in. No big deal. If she does a driving improvement course, the court will usually dismiss or reduce those, since her driving record wasn't bad. When I showed up for her, I found out that she had been driving 70 up an unplowed snow lane to get around all the other cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated had already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she did claim she had just forgotten to mention it. Now, maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay this one. I legitimately do that all the time during consults, give my honest assessment if the case is even worth doing. And so by omitting that detail, she harmed herself for no reason. At least she took it well and didn't get defensive. My parents spent most of my childhood and were still arguing it years after ID left home, TBH, embroiled in a messy divorce. One of their biggest arguments was about my parentage. My mom claimed that my dad claimed that I wasn't his child and refused to engage with him until he admitted he was wrong. My dad refused to admit he was wrong and refused to engage with my mom until she apologized. Much later, I found out that those years spent arguing were all down to a typo on a court document, which had my date of birth wrong by 10 years, thus having me being born after my dad had a vasectomy. Neither had mentioned the obvious typo to their legal representation, as I guess they thought fighting pointless battles in court for 5 years was preferable to simply amending one number on a paper document. As an aside, one parent in particular went through multiple solicitors barristers, insistent that each one had mismanaged the case, and to this day is still convinced that they were a model client who just had bad luck choosing representation.